The voter forums that we run here are presented by the League of Women Voters of Bellingham-Whatcom County and the City of Bellingham. The League encourages informed and active participation in government. We work to increase understanding of major public policy issues and to influence public policy through education and advocacy. We do not support or oppose candidates or political parties, and we welcome men and women of all ages to join the League. We're starting with the candidates for the Court of Appeals Judge, Division 1, District 3, Position 1. Right. So without ado, I think I'd like to introduce Jill Bernstein, who will be the moderator, and she'll explain the rules for the forum and take us through the process. I think you'll introduce the candidates too.
That would be my pleasure, and thank you so much, Heather. We have today with us seated before us 4 of the 5 candidates. Mr. Seguine hopefully will be joining us, and we would welcome him if his arrival has just been delayed in some way. So we're going to go in alphabetical order for most of this, and the first seat is with Cecily Hazelrigg-Hernandez, and Ms. Hazelrigg-Hernandez has told me I could call her candidate Hernandez, which is how she's referred to in the courtroom, recognizing the full name is a mouthful and a half. Next to her is Lisa Keeler, Rita Latsinova, and Roger Leishman. So welcome to the candidates. And one of the things that you need to know about a forum as it relates to judicial candidates is that it's just a little bit different in that the rules of ethics that govern what judicial candidates can and can't say also govern what sort of questions we get to ask them. Judicial candidates are by design nonpartisan, the notion of blind justice, right? Nonpartisan positions. And they also can't speak to any issue or any case that they may be called upon to decide. And so some of the things that we think about as hot button issues in our community and are probably in your mind about how would one of these 4 candidates decide issue X or issue Y, they're really not going to be able to speak to this afternoon. They're going to have to wait until issues are presented to them on the bench and decide them on the facts that present in the particular case that they're called upon to decide. Now, as Heather was trying to describe to you this position, I would tell you that a bunch of lawyers like myself got together recently, and we took some time trying to parse out exactly what this position was. And as Heather pointed out, it's not that obvious. So here's what it says in the voter pamphlet, the office description. It just tells us that most cases are appealed from superior courts. They go directly to the Court of Appeals. Those certain specific types of cases go directly to the Supreme Court. The court decides each case after reviewing the transcript of the record that came in the case below in the Superior Court and considering the arguments of the parties. That means that litigants themselves are not before the court when a case gets up to the Court of Appeals. The court is organized into 3 divisions with headquarters located in Seattle, Tacoma, and Spokane. Hello, Mr. Seguine. Hello. This is candidate Seguine. Each division is divided into 3 districts with a specified number of judges, each elected to a 6-year term. The annual salary is $181,263. So that's, now you know. Before we begin, there are some rules for the forum. Each candidate will have up to 2 minutes for an opening statement. They will have 1 minute to respond to each question and will make a 1-minute closing statement. Each candidate has a challenge card. Candidates, you want to hold up your challenge card? There you go. Candidates may use this card to challenge or rebut their opponent's response. The challenging candidate will have 45 seconds to state the challenge, and his opponent will have 45 seconds to respond to the challenge. Each candidate may use their challenge card only 1 time during the question and answer period. Candidates, simply hold up your card when you wish to challenge your opponent on a particular question. But please wait until all candidates have responded to the question before making your challenge. Now, we have a couple of timers here who are with us today, and that is They are Carol Como and Shemaya Contouras, who will be keeping track of the time. Timers will flash a yellow sign when 15 seconds remain and a red sign to signal when time is up. If a candidate continues talking after the red sign, a bell will be rung to signal stop talking. And after that, it's a hook, and after that, you don't want to know. Due to the limited amount of time that we have and our desire to include as many questions as possible, please be respectful of the time limits. Audience, an important goal of the League is civil discussion, and to that end, we ask that those in the audience be respectful and refrain from comments, as well as hold your applause until the conclusion. As Heather said, we encourage members of the audience to provide written questions for the candidates. Anytime that you've got a question, raise your hand, and one of our runners will bring you an index card and a pencil. The questions you submit need necessarily be asked of all of the candidates, so there won't be a question for one candidate that excludes the others. And remember that the ushers will come and assist you with any or all of this. Try to make it as legible as possible to help me too. So I'm going to vary the order of the candidates' responses during the forum. They're seated in alphabetical order. We're going to have one person start and one person finish, but we're going to move through this to keep things fair to all of the candidates. I've got a little chart here, and hopefully I'm going to stay in order, and if I don't, someone will come along and give me that hook. So let's start with our opening statements, and Mr. Seguine, would you start, please?
Thank you. Good afternoon. My name is Tom Seguine. I'm a candidate for the Washington Court of Appeals, as Jill explained. This is for the voters of San Juan, Island, Whatcom, and Skagit County. I'm asking you to consider a vote for me because I believe I have the right blend of experience to fill this position. I'm going to suggest to you that there are three big things to think about here in terms of the candidates. One is appellate experience, two is legal experience handling criminal cases, and three is legal experience handling civil cases. Starting with the appellate cases, my work in the appellate courts goes back to 1990 and extends fully to the present day, where just yesterday I received a brief in a case that I'm involved in Division I. Between those two times, I have probably handled, I don't know the number, but I hazard to say at least 50 appellate cases. So if you're looking at that particular thing, you can check the box there. Number two, the Court of Appeals caseload is comprised one half of criminal cases and one half of civil cases. I have practiced criminal law for about 28 years, maybe 30, depending on how you count. It makes sense that the candidate who fills that position has that background. I have it, so that box can be checked. Third, as I said, the other half is civil. Since 2007, I have been in private practice, practicing throughout Whatcom, Skagit, and Island and San Juan counties, and I have had a very diverse civil caseload over that time period, which has included going up to the Court of Appeals repeatedly over that time frame. So if you can check those three boxes, I'd ask you to check a fourth, the one with my name on it on your ballot on August 7th. Thank you.
And next, candidate Leishman, please.
Good afternoon. My name is Roger Leishman. I'm one of the candidates here, as you see. As I think about what it means to be an appellate judge, particularly for the Court of Appeals, judges are people who are driven by a desire to get it right. And in the first sense of being able to get to the right answer, to be fair, to make sure everyone involved in the process feels like the process has served them and that justice has been served. But also, and especially at the Court of Appeals, getting it right means getting to the right answer. Judge Susan Agudu, who used to be on this court, described the judges of Division I as the last generalists in the law, because you take whatever kind of case comes to you, and you have to be prepared to see how those cases and how those issues fit in with the whole landscape of the law everywhere. In my experience, I went to Yale Law School. I worked for a big law firm. I was a gay rights lawyer for the American Civil Liberties Union. I was an appellate lawyer. I realized early on I really enjoyed that practice, and so I practiced in Division I in the state Supreme Court and the federal courts for the last almost 20 years now. But what I would bring to this is a diversity of experience, but also a perspective of justice and of its application to every single case. You want to figure out what the right rule is, but you want to make sure you apply it correctly and make sure everyone involved knows that justice was served. Thank you. I look forward to answering your questions.
And candidate Latsinova.
Thank you, Jill. I'm Rita Latsinova. I live in Friday Harbor, and I work in Seattle. I'm an appellate lawyer. I have been practicing appellate law for 23 years in all appellate courts in the state of Washington, but focusing primarily on Court of Appeals Division I. For as long as a retiring judge, Mary Kay Becker, has been on the Court of Appeals, I've been arguing cases in front of Judge Becker. And in fact, I owe my first appellate experience to Roger here. We started in the same law firm, and the first case I ever was thrown in was a case that was tried, and then Roger moved to work for ACLU in Chicago. I inherited the appeal. So thank you, Roger.
We won, eventually.
So it was, my appellate career started by chance because of what I just described, but it continued by choice. I love the work, and I continued doing that work, and I'm still doing that work because I love it. It's intellectually challenging, it's exciting, and there is always something new. But you know, lawyers have a responsibility to do more than just do their job. I believe very passionately that we have to give back to the community that we serve. And when I ask myself, what can I do to contribute? My answer generally is, my ability is best applied in pro bono cases where I can contribute my work to cases that otherwise would not see the Court of Appeals or even the trial court to begin with. So I have volunteered as a pro bono lawyer for ACLU and Northwest Immigrant Rights Projects, and I'm happy to say that I have been endorsed by 4 current and former Supreme Court justices of Washington Supreme Court. Thank you.
And candidate Keeler.
Thank you. Good afternoon, everyone. My name is Lisa Keeler, and I'm running for Court of Appeals Division I. Thank you for being here, and for everyone who's tuning in. I know how important it is to be educated about these races. I love the law, and I care a lot about the impact it has on people, and I like to be of service, and that's why I'm running. I have experience doing some criminal work, some family law work, and a huge broad experience in civil law. I've practiced out of Bellingham my entire career, serving Whatcom, Skagit, San Juan, and Island counties. I was in public practice, serving the state and residents of Washington with the Washington State Attorney General's office. I'm now in private practice. Going into private practice has given me the opportunity to serve on the bench. I'm a substitute or pro tem commissioner here in Whatcom County, and I get involved in my community. I have always been involved in access to justice issues, serving on the board of directors for Law Advocates, the local volunteer lawyer program, and getting involved in other aspects to ensure that everyone has access to our courts. Because of my professional experience, my personal reputation, and my experience and service to the public, I am endorsed by all the Whatcom County Superior Court judges. I'm endorsed by commissioners in Whatcom County. I'm endorsed by the Bellingham City Judge, Judge Lev. I'm endorsed by Alan Hancock, Superior Court Judge in Island County, and I am endorsed by Chief Justice Mary Fairhurst, Justice Stevens of our Washington State Supreme Court, and many, many others. Again, I want to be of service to my community. I've created a broad experience, and again, I strive for excellence and fair treatment of all. So I ask you to vote for me, Lisa Keeler.
And candidate Hernandez.
Thank you. Good afternoon. I'm Cecily Hazelrigg-Hernandez. I'm a trial attorney with deep roots in the communities represented by the position I'm seeking. I was born and raised on Whidbey Island, moved to the mainland after high school, and attended the Skagit Valley College paralegal program. I was a young single mother, and so I was looking for a way to build a career that served my community, that capitalized on the skills that I had identified. Those skills were research and writing based, an ability to translate the law, if you will, from what is sometimes exclusive language to more accessible language. And it was a way that I could use that skill set to serve my community, but also provide for my daughter. Through that experience, I moved on to Western and resided in Whatcom County, where I completed a bachelor's degree in American Cultural Studies. And at that point, my daughter and I moved to Spokane, where I earned my law degree. My educational path was broken into baby steps because, as you might imagine, taking on that entire path as a single parent was an absolutely magnificent but sometimes daunting challenge. That said, we've had wonderful adventures, and I have been enabled to seek a career that not only serves my community, but sets an example for my child, now 2 children, about the value of community service. My entire adult career has been centered in Skagit and Whatcom counties. We lived up here until about 4 years ago, with my daughters attending local schools here. I commuted to the Skagit County Public Defender's Office, where I found my passion in serving traditionally marginalized communities as a trial attorney, working in criminal defense. My background includes work in family law, immigration work, and other community service outreach.
Our first question today will begin with, many voters express confusion over how to choose a judicial candidate. How would you advise a voter to choose a judicial candidate in a race where you are not running? So let's start with Mr. Leishman. Candidate Leishman?
In my experience as a lawyer, people always ask me who to vote for in judicial races that I'm not running in. I'm not suggesting that you ask me who to vote for in this race, because you probably can guess what the answer will be. But it is an opaque process, and you find out about the person, because at the end of the day, what kind of a person they are from their website, their writings, their speaking, and that gives you an insight into what kind of a judge they're going to be. But really, the other way to do that is to look at the things that you've done. Google people, find people's briefs. Who can write? Being an appellate judge involves a lot of reading and a lot of writing. You need to be good at that. You can see what people have written, what people have done there. My parent, I'm from Bellingham, and I know that I'm just thinking, sitting here, my brothers all went to high school here, and so I'm hoping everyone confuses me with one of them and thinks I'm the soccer star or the swimming star. But it really is an opportunity to ask, who do your friends know, and how have they been able to make their choice? Thank you.
And now, Candidate Keeler.
Thank you. What I tell people is to look at their experience, look at their judicial endorsements, and look at their community experience. Again, I want judges who are fair, who are balanced, who have a good reputation, and have already proven that they're experienced in the community. So people ask me, again, all the time as a judge, who are you going to vote for? What do you look for? And again, I do recommend asking about people. Ask the lawyers you know, but again, take a look. What kind of experience do they have? Do they have experience in appellate work, family law, criminal, civil? Do they have judicial endorsements? Again, we want a strong, independent, nonpartisan judiciary. These are people who see these practitioners in their courtrooms. And again, do they have proven community experience? Not just what they say, but what they've actually done. And I have all 3.
Candidate Seguine.
Fundamentally, I think you should try to find someone who is fair. That's what all judges are supposed to be, fair, and that's a tricky question because it's hard to know the judges personally. I agree with Ms. Keeler that you have to look at endorsements. I have some of those. Probably all the candidates here have something along those lines. I think, have to try as best you can to figure out what court and what position is at issue, whether it's a district court, a superior court, or an appellate court, as much as you can understand about that, and then again to talk about what Ms. Keeler talked about, experience. And in this particular case, as I said in my opening statement, there's kind of these 3 big things that you can talk about, and I would suggest to you that I'm the candidate sitting up here who probably has more experience than anybody else. Thank you.
And candidate Hernandez.
Thank you. I agree with many of my colleagues up here that looking at outside experience in the community is critically important. Certainly, as is courtroom experience, I would agree that looking at judicial endorsements does matter. These are the judicial officers who watch us practice. As a trial attorney, I have spent thousands of hours in the Skagit County courts, and so part of my thought process was seeking advice from the judicial officers who've seen me over the years, and seeking that support and input and advice is absolutely critical. So I would agree that is very important. I would also agree that community service and outreach absolutely matters. I think it is important to realize that we are impartial officers of the law, but we are also shaped by the life experiences that we carry with us, whether that's our own direct experiences or the experiences of the lives we've impacted through our career and in the community. Thank you.
And candidate Latsinova.
I think the answer greatly depends on what kind of judge you're looking for, what you're voting for. Is it a trial judge or is it an appellate judge? Because the experience as a trial lawyer doesn't necessarily translate into experience as an appellate lawyer or appellate judge. These are different methods of approaching legal issues and legal problems. So for a trial court position, I would look for somebody who has a lot of trial experience and has endorsements from people you trust, and also has life experience that matters to the voters. For the appellate, respectively, for the appellate position, I would look for somebody who has the greatest depth of appellate experience and also life experience that matters. I would look at how people spend their free time. Do they contribute to the community? Do they put their time where their mouth is? Do they do pro bono work? Things of that nature. Thank you.
For our second question, we're asking, how do you think your experiences would shape and inform your work for the court if you are the successful candidate? And for this one, it starts with candidate Latsinova.
Well, I have the unique, in this group, situation. I am a naturalized U.S. citizen. I came to the state of Washington in 1990, and I developed a new career for myself. I went to law school, I became a lawyer. I worked for 3 big law firms. I was involved in pro bono cases, and I'm interested now in being an appellate court judge. So this life experience, I think, gives me the added motivation to represent people who are diverse. I am in the position to understand the full range of diversity of people who come before the courts in the state. I have a stop sign. So
Candidate Hernandez.
As I mentioned a moment ago, one of the things that I certainly do bring to the race is my trial experience. I would unfortunately disagree with one of the candidates. I do think that trial experience absolutely matters for an appellate judicial position. The job of an appellate judge is to review the decisions of the trial court. And when reviewing the transcript that goes up to the Court of Appeals, there are certain things that don't always translate. There are things like tone and body language and pacing. Those aspects of trial work are absolutely critical. This experience does matter as we're building that record that we send up to the Court of Appeals. So that is absolutely something that I would bring with me. I'm also a former adjunct instructor at Western Washington University teaching the American Cultural Studies program. Based on my work as an academic in the field of cultural studies, I bring an intersectional analysis to all of the work that I do with an in-depth understanding of the impact of issues like socioeconomic status, immigrant status, race, gender, sexual identity to the institutions we encounter as citizens.
Candidate Keeler.
So I have a very broad and very balanced experience. When I worked for the Washington State Attorney General's Office, I did child abuse and neglect cases. I worked with families and parents who struggled with mental health issues, drug addiction issues. I've handled personal restraint petition for a criminal accused. I have sat on the bench. I see the impact that law has every day on our community and on individuals, on small businesses, on government. I've represented all of those people in lots of different places. I know what we need from the Court of Appeals so that we can have clear, understandable law that we can use in our courtrooms every day. And I have experience doing strategic planning work for nonprofits and in improving systems. And that's the breadth of experience that I can bring to the Court of Appeals.
Candidate Seguine.
I have represented people from these 4 counties since 1990 in one way or another. I served as a deputy prosecuting attorney for Skagit, Island, and Whatcom County from 1990 to 1997. From 1997 to 2002, I was the I was the assistant chief criminal deputy in Whatcom County doing appellate cases. From 2003 to 2007, I was the elected prosecutor in Skagit County, and from 2007 onward, I've been in private practice. Along the way, I have represented plaintiffs and defendants. I have prosecuted, I have defended people in criminal cases, I have represented people in actions that they have involving their family and estates and personal injury cases. All of those things have given me the balanced approach that is necessary to be an effective judge in the Court of Appeals.
And Candidate Leishman.
I've been thinking about this position for about 10 years now, looking into it. Division I is the largest appellate court in the state. There are 10 judges on this court. There's only 9 in the state Supreme Court. Of those 10 judges, 7 are from King County and Seattle, 2 are from Snohomish, and this one position is everyone else. So, and the court makes decisions in panels of 3 judges. Appellate court judges don't do anything themselves. Everything you do is collegial and a lot of writing. So what translating our prior experience of doing that means sitting down, reading those briefs, meeting with the other 2 judges who have been randomly assigned to the case, being collegial, because it's one of these things where you don't do anything yourself. You need to have 2 other people who agree with you. And from the point of view of someone who's lived in Whatcom County and in Island County, having someone representing our 4 counties against the 9 of them in the big city is very important, to have someone who can quietly and collegially bring that perspective to the court. Thank you.
Our next question is, how would you distinguish yourself from your opponents? And with this one, Candidate Keeler, please.
Thank you. So again, I have experience doing family law, some criminal law, and a very broad scope of civil practice. I've done appellate work. I've been very, very involved in my community. I work with law advocates, our civil legal aid program. I've gotten involved with Washington women lawyers. The proof is in the pudding. I believe very strongly about a strong, independent, nonpartisan judiciary, which is why I'm the only one who didn't seek or send proxies to seek any political party endorsements. I was encouraged to do that. I was told that it would help me win an election. But I decided that, again, nonpartisan means nonpartisan. I bring a very broad, balanced experience working for the government, working for individuals, working for small businesses. And that and the breadth of judicial endorsements that I have is what sets me apart.
Candidate Leishman.
2 or 3 years ago, I would have said I was the candidate with the broadest experience. I've been on the Board of Governors of the Bar Association. I've been a leader in bars, associations, and nonprofits in that. I've done a diversity of criminal, family, other things. But what I want to share now is 3 years ago, I moved to Bellingham to take a job that didn't work out. I was diagnosed with PTSD. And I have been home with my 3 children. I'm a single father. As a single gay disabled person, learning how it feels from the other side to deal with discrimination, to hire a lawyer to represent you against your former employer, to see how you can rebuild your life, having had a lot of success and then a massive failure. I think that all the people you see here have a depth of experience, and all of us, I'm sure, would make a fine judge. What I add now that I didn't have a few years ago is I have seen what it means to struggle, to parent, and to work with everyone else, and I think that my life experience has made me a better person.
Candidate Hernandez.
Thank you. I would agree with candidate Leishman with regard to the value of seeing all the different sides of the justice system as far as what that can bring to a judicial officer. I have deep roots in this community. I grew up here, left briefly when my dad was assigned to a military detachment on the East Coast, was back here by 1981, and then left the Northwest counties only briefly to attend school. Returned immediately because this is the community where I wanted to engage in my service. In addition to the teaching that I've done, the trial work that I've done, I've been engaged in my communities regardless of whether I was living in Whatcom or Skagit County. I represent my office in developing immigration policy with the Skagit County Jail. I work with the Skagit Island Community Partnership for Transition Services, looking at addressing recidivism in the community through outreach to formerly incarcerated persons.
Candidate Latsinova.
I would say that I am a candidate who does not need to learn on the job. I have been doing appellate work in Division I for 23 years, and I know exactly what this work involves, and I can do it immediately on day one. I do not need an education. Number two, I think you need to look at my pro bono work. I have made a very big commitment to pro bono work. I have represented women in cases against federal government, in cases that involve reproductive rights. That didn't necessarily make me popular among my partners in my firm, but I did it anyway. In another pro bono case, I am proud to report that I sued the federal government for failure to timely naturalize 500 legal immigrants. And as a result of my work, they all won the right to become naturalized U.S. citizens like me and vote in the 2008 presidential election.
And candidate Seguine.
So the key here is to try to pick the person who will best serve and represent you. And I talked about the service aspect of it, and I would encourage you to think about those big three things I talked about: appellate experience and criminal experience and civil experience. I think you'll find if you do the comparisons, I'm the only person who has that blend at such a deep level, that is 28 years. The other thing is the representative piece of it, and some of the candidates have talked about that. I've lived here since 1990 and spent my time working in all of the courts within the 4 counties, and I think probably more than any of the other candidates.
Our next question is, which is more important, the letter of the law or the intent of the law? And how do you balance the two? Starting with candidate Hernandez.
Thank you. As candidate Latsinova indicated, I think there are differences in the types of judicial officers, and with regard to the Court of Appeals, our job would be to apply the existing law to the facts of the case. And I think in engaging in that analysis, it actually requires a very solid balance of both. You look at the existing case precedent, you read it carefully, you look at the subtleties of language, and you look at the laws that are applicable in that particular case. You look at the legislative intent. As practicing attorneys, we do rely on legislative intent to form some of our arguments and develop the positions for our cases. So this job as an appellate court judge would require a balanced analysis of both of those issues and applying the existing case law to the facts of the case before you.
Candidate Seguine.
The law is really policy. We all know that. It's created by the legislature for the most part, and lawyers are bound to follow what the legislature does. We also know that the legislature is imperfect in the way they draft things, and so there is always room for interpretation. There's another concept in the law called stare decisis, which means that if we decide something one way, we ought to try to keep deciding it the same way going forward. I believe in all those principles, particularly stare decisis. I think that's very important because people need to have some sense of consistency in the law. By the same token, there's something else called strict construction in the law, which applies to legislation and other things. And sometimes that can be the appropriate thing, but I think always a judge at whatever level has to, in the back of his or her mind, look at the issue of fairness and try as best they can to reconcile those competing ideas in any type of case that's in front of them.
Candidate Latsinova.
Going back to Candidate Hernandez's answer, legislative intent is important when you're construing a statute. When you're not construing a statute, legislative intent is irrelevant. When you are dealing with an issue that is not controlled by a statute, there's a Washington rule. It's in the statutes, RCW Title IV, that says, "The rule of decision in all courts of Washington state shall be the common law, so long as it is not inconsistent with the Constitution, the statutes, and conditions of society." So it's all there. In statutory construction, legislative intent is important. In common law cases, you have to follow the Constitution of the state and federal Constitution, and it has to be consistent with conditions of society. Those are the rules.
Candidate Leishman.
As I said in my introductory sentence, being a judge is about wanting to get it right, both in the sense of the fair answer and the correct answer. And I think we would all say that this is a balancing that everyone is striving for. I think the one thing I would add to this that I think is a useful governing principle is the idea of something called special pleading. That's when you ask for a rule that applies to everyone else and not yourself. And that is often the problem with cases and with case law is why we step back, and it's so important to think of the law as this huge tapestry, this map that you want to make sure that you pick the right rule and you apply it in a fair and coherent way, that you're comfortable that anyone else in a similar situation will be treated the same. And if you step back and you look at yourself and you thought, I carved out an exception to let this person win this time, you're not doing your job right.
And Candidate Keeler.
The letter of the law matters. The intent of the law can matter, and how the law applies to a particular set of unique facts matters greatly at the Court of Appeals. The letter of the law can come from statutes, can come from rules, can come from case law. The intent of the law, or as the law is applied in other cases to build that body of law, can come from legislative intent or other cases that make up that common law. And most importantly, we need to look at the particular facts in a case and how the law applies there. So it's a very complicated issue, and again, my goal would be to make it as understandable as possible when you're applying that law to these particular cases, because it might impact other cases later. The decisions of the Court of Appeals become law.
Our next question, when considering a case, how much weight do group rights have in relation to individual rights? And with this, Candidate Seguine, please start.
Well, when you start to talk about those kinds of issues, you probably get into the issue of constitutional law. And our Constitution is a contract between you, the citizens of this country, and the government, and that could be the state or the federal government. There are certain rights which are inviolable. We know that through the Bill of Rights, and so there's sort of a black line there, or a line that can't be crossed. Having said that, as a prosecutor, for example, I was involved in many, many cases where there were issues relating to search warrants and things of that nature, which put the rights of society, so to speak, against those of the individual. And the best answer I can give to you is that there just needs to be a balancing, and you see that over and over and over again in every single case that involves those types of things, and I strive to do that as an appellate court judge.
Candidate Latsinova.
picking up on where candidate Seguine has left off, I think in the state of Washington, in the courts of the state of Washington, this balance is especially nuanced because Washington Constitution has some important differences from the federal Constitution, and some of these balancing decisions are made differently. For example, in the state of Washington, we have an explicit right of privacy that doesn't exist in the federal Constitution. So the balance between, for example, search and seizure on the federal Constitution may be decided one way, and the Washington State Constitution requires that it be decided a different way and requires a different outcome. So I guess the short answer is it depends.
Candidate Leishman.
I agree with Ms. Latsinova. It will depend, and because as but we were told from the beginning, we aren't supposed to talk about individual cases, so this becomes so abstract. I wanted to use it as a chance to talk about a specific thing. Half the Division I's docket is criminal, but that's because all criminal lawyers are entitled to an appeal for free. And so there's a lot of law going out there, the search and seizure law, the law of confessions and Sixth Amendment, and that's a part of the law that is very thoroughly already done. And so it's important for us I guess this is my way of saying we need to look for judges who are familiar with the other areas of law where we haven't worked out these tensions quite so much, whether it's in family law or I practice in civil law. But fortunately, the answer in the criminal context is usually there's a pretty clear set of rules that will help us figure out how to protect the rights of defendants while at the same time keeping a community that's safe.
Candidate Keeler.
So in my experience, every case is about a balancing of rights and interests. One individual versus another individual, a group of individuals against another group of individuals, a business, or challenging something the government claims that they have a right to do. So the first question always is, what is the right? What do you have a right to under the law? What's the balance of your rights versus somebody else's rights? And that comes from, again, a great body of written statutory law, from our case law, and again, from our constitutions here in Washington and in the United States. Again, it really does just depend on each individual circumstance. And I think, again, that's why it's important to have somebody who has a very balanced perspective and sees what it's like with these individuals, these groups, this government, and balancing all of those rights, which are always in conflict.
And Candidate Hernandez.
Thank you. This learned panel has certainly hit on the key aspects of this issue, which is the balancing, and it depends. It depends is often the stock answer from practicing attorneys because these issues are so fact-specific. I would agree that every single case requires a balancing of those rights and a deep understanding of how that interplay is unique to that case, those parties. I would suggest as well that the standard of review is different in a criminal context because the rights that we're talking about there go to those individual rights raised in the question. They go to liberty interests, potentially raising the issue of incarceration. So if you are able to apply that very high standard in terms of the analysis of an individual's rights, this transition to a civil context where the standard of review is somewhat different.
In 2011, the Washington State Supreme Court created a task force called Race and the Criminal Justice System. The task force concluded that people of color faced disparate impacts in every aspect of the justice system. What are your views on whether the courts as a whole deal effectively with racial bias? And with this, Candidate Leishman, would you start us off, please?
I was on the board of the Bar Association during that task force and was actually in Olympia at the Temple of Justice to hear the report. And it was blistering and depressing because every step of the way there are biased outcomes. Face it. we live in a country where there's implicit and explicit bias. The thing that was the most encouraging that I heard from that was there was one place where the outcomes were not biased, and that was when an individual judge was sentencing, and if that judge stepped back, thought about it, looked at their own biases, and tried to overcome them, the sentencing outcomes were completely fair. That gave me an immense amount of hope that if we are examining ourselves and we look at the system and we acknowledge it's imperfect and we're imperfect, but we can overcome this with the application of the kind of attentiveness and the kind of judge I would want to be. Thank you.
Candidate Keeler.
There's a lot more that the courts can do. We are learning more and more from just neuroscience, from social science, how implicit bias works. And I think the most important thing is to educate ourselves. I've been lucky enough to participate in implicit bias trainings. I just participated in a recent one on race equity that we're doing, again, for the nonprofit to make sure that we're serving all of our community in a fair, equitable way. And so I think the most important thing is to educate judges, educate lawyers, educate other people within the court systems about what implicit bias is, how it works, so that we can check ourselves and do our best to make sure that those biases are not what is informing our decisions, but in fact the facts of the case and the law are.
Candidate Seguine.
I'm soon going to be 58. I'm a white man, and I don't pretend for a moment to understand completely and appreciate fully the issue of racial bias. I sometimes like to think intellectually I can do that, but I don't really think I can. I have had experiences throughout my career with this sort of thing as a prosecutor, where I have prosecuted people of color. I've also defended people of color. I've also prosecuted a civil rights lawsuit on behalf of a couple of color, an employment lawsuit, and we presented those issues in federal court and we didn't succeed. And we ran into brick walls with people saying that this isn't possible with the people who, were the defendants in the case. Now, my clients believe to this day, though they lost, that that was true. So I can only tell you that going forward, I have to take those things into consideration and believe that it exists, and I will continue to do that within the realm of reason.
Candidate Hernandez.
Thank you. One of the issues that drew me to the law in terms of utilizing those skills that I had mentioned earlier for my community was looking at disenfranchisement and privilege and who has access and who doesn't. Again, my work in American cultural studies helped me to cultivate a deep foundation that is based on the concept of intersectionality and a historical framework, a sociological framework to help me understand the way that these different aspects of our identities impact our interactions with the social institutions like education, like the justice system. I'm a bilingual attorney. I represent Spanish-speaking indigent defendants in my office in their primary language. I've lived, worked, studied, and taught abroad. I have taught implicit bias training in my office. I have educated our probation office, our judges, our jail staff, and opposing counsel about the impact of implicit bias.
Candidate Latsinova.
I agree with candidate Leishman that the data is clear. The outcomes of sentencing decisions, unfortunately, are different for people of different races in Washington. The data is absolutely crystal clear. The question then becomes why. And many of you have probably listened to NPR, the Shankar Vedantav show about hidden brain. And yes, there are biases that are explicit. The more insidious bias, frankly, is the implicit one that you may not even be aware that you have. And I think training helps. I agree with people who said that training is important. I have gone to training. But I think the most important thing that each of us can do as citizens, and certainly it's true for judges, is always ask yourself, why am I doing what I'm doing? Is there you have to train yourself to be vigilant.
For our next question, while serving on the bench, do you believe you have a role in bringing important legal or judicial issues before the public and/or the legislature? Why or why not? And let's start with candidate Latsinova.
Yes. I believe that judges on the Court of Appeals especially have a responsibility to educate the public, including the public in their districts, about the work that they do, about the cases they decide, about the outcomes in these cases, and about the important work of the court in general. I think the courts have a great educational role, and I would be happy to fulfill that role. As a former teacher in my former profession, I would be very happy to do that. There's another aspect of bringing the law to the people, so to speak. There are many people who are unrepresented or underrepresented in the Court of Appeals, and some courts do a better job of having self-help guides for people who are underrepresented. And I think the Court of Appeals could do a better job in that regard.
Candidate Hernandez.
One of the hallmarks of my career, both as an educator at Western Washington University and as an attorney, has been mentoring and working as a support system for people seeking greater opportunities, either in education or in the legal field. One of the interesting aspects of an appellate court judge is that you often have law clerks. That is an incredible opportunity to mentor young members of the community, young lawyers, whether they're new to the practice or new to life experience, in terms of building the diversity of the legal community and making more inclusive pathways, I guess, to the justice system. So that would certainly be important in addition to regular public outreach.
Candidate Keeler.
I asked myself 4 questions as I was trying to discern whether or not to run for this position, and I asked the same questions of judges who know me, friends, close people who are close to me. The first question is, am I qualified for the job? Yes. Do I want the job? Yes. Can I survive a campaign? So far, so good. The last question I asked is, what else can I do when I'm a judge? And I looked at the judicial canons because I like to be involved in my community, and I'm a big advocate for access to justice. And the answer is yes, the courts have a huge role, and I think need to take a more active role in, 1, educating the public about the courts, about civics, and about the law in general, but also for advocating for access to justice. And frankly, our Court of Appeals is our least active bench in that avenue, and so I can bring all that to the court.
Candidate Seguine.
Absolutely. The judges are, and particularly the appellate court judges, play a very vital role in the system that we have here in Washington. So I would certainly support and participate in continuing legal education in whatever form it might take. Over the top of that, however, and it's been alluded to here, a judge has to be very careful about going in too far and getting involved in things that in the legislature that sort of kind of cross the line. So with that proviso, again, the answer is absolutely yes. One of the things that the Division I did in the past, which it hasn't done in about 10 years, is it went on the circuit and brought the court up to Whatcom County and Skagit County. A panel of 3 judges came up and heard cases, and that hasn't been done. So I'd like to bring that back to you folks as well.
Candidate Leishman.
I'm in complete agreement that there is much that you can do and much more that we should do, consistent with our obligations. I think one of the messages that I hope that everyone in the room is hearing is there is more that this particular court, the largest appellate court that sees what the volume is, has a lot to say, that could talk to policymakers about where the greatest needs are, but also that the individual judges can and should be out in our communities, especially as the lone judge away from the traffic gridlock down there, to be in the community. And for me, it would be the same issues, not representing parties anymore, but caring about children, about diversity, about access to justice and pro bono representation for people. I think there's a lot that judges can and should do.
For our next question, has there ever been a time when you chose to be principled to your personal detriment? And can you give an example? And that would start with Candidate Keeler, please.
Two things come to mind. One, I haven't seen if there's any detriment yet, but I was encouraged, frankly, very heavily to seek political party endorsements and partisan endorsements as part of this run. And I, again, feel very strongly about the nonpartisan nature of the judiciary, and so I stood my ground. The other thing that kind of came to mind is when I was first practicing, I had a situation where I did not feel it was ethical for me to take the action that I was being asked to take. And it was hard. I was young. I had less experience, and I was being asked to do what was called my job, to move forward with a particular action involving a family, and I had to stand my ground. I ultimately didn't risk my job, which was great, but it definitely impacted relationships, except in the end they realized that I was making the correct ethical decision.
Candidate Leishman?
For me, this question comes to the closet. I say this as someone who came out late in life at 30 years old, grew up Mormon with a conservative background, and all my life there's always been pressure to be in the closet one way or another, and every time I've learned to resist that, it has been the right answer. Now that I've been living for the last 3 years with mental illness, that having PTSD, I've again faced those same problems I don't know if anyone noticed it, I fiddle with this little purple thing, because one of the symptoms of my PTSD is I have trichotillomania, which means I pull my hair out compulsively, and I use this to keep from doing that. I could hide that. I could say we shouldn't have judges who've dealt with problems or who've been outside the mainstream. I'm not going to do that. I haven't done that. I continue doing that. I believe that I am a better candidate and will be a better judge because I've been honest about who I am.
Candidate Hernandez.
Thank you. I think one of the ways that this has impacted my life, and I don't necessarily actually even would consider it a detriment, I certainly passed up opportunities professionally to continue working with folks who didn't otherwise have access to the legal system. That has always been critically important to me. It could have meant a different livelihood for my family. Those things are certainly very important, but they're not of the utmost important. And so there were some hard choices along the way about where we would go as a family that would allow me to provide for them in a way that is safe and they have their needs met, but also balance the value of the work that I do and the service to the community.
Candidate Latsinova.
Well, the main example that comes to mind is my decision to take on pro bono a case that's called Jane Doe versus Rumsfeld, and you can guess who the defendant was. It's a case about reproductive rights. It involved the plaintiff who was pregnant and her fetus had anencephaly. It's a condition when the fetus develops without a brain. There's a brain stem and nothing else. And the government that insured her, through her husband who was in the armed services, refused to pay to terminate this pregnancy. And so taking on this case all the way through Federal Circuit, Ninth Circuit, and District Court initially made me rather unpopular among some of my partners. But I did it anyway, and I don't regret it.
And Candidate Seguine.
There are many, many examples in my career where I have done what has been described here, taken a position which was principled and caused me to have, an and aftermath from that. Some of them, I dare say, were with our moderator today, who, when I was a prosecutor, she was a defense counsel, and certainly we have great respect for one another, I hope. But beyond that, as well, I have disagreed with Superior Court judges periodically over the last 28 years as prosecutor and in private practice. And judges in the Superior Court have made decisions which I believe to be an error, and I have taken them up as an appellant to Division I, and I've asked that their decisions be reversed. Now, that doesn't sound like that big a deal, but that's part of the appellate process here. And the next day, word gets around a little bit, and you have to appear in front of those judges. So it's not always the most comfortable thing, but it's an example of what has been asked in the question.
The United States incarcerates a larger percentage of its population than most countries in the world. Why is the United States incarceration rate among the highest? And do you think an appellate court judge has a role in addressing the number of people in jail? And with this, we'll start with candidate Hernandez.
I think that the role an appellate judge would have in addressing that question or that issue, again, I think it's going to be very limited in scope with regard to the case that is before the court there. That this is a bigger policy question, and perhaps that would be something that would be addressed through that public outreach that we were talking about a little while ago. But again, the focus of the appellate court work is simply applying the law as it exists in the state of Washington to the case that is before that panel of judges. So as far as a broader picture impact, I don't know that that's necessarily something that would be possible from the bench per se, but certainly it would have a direct impact on that particular litigant. And again, through public outreach, there might be the opportunity then for bigger policy change.
Candidate Seguine.
I agree with that for the most part. An appellate court is like the judicial branch is that branch of government which doesn't get to pick and choose, for the most part, what cases get before them. The parties decide there's a controversy, and it makes its way through the courts and eventually to the Court of Appeals. So an appellate court judge's ability to deal with those types of issues is limited. Having said that, I was a prosecutor for a very long period of time, and I understand very clearly the extreme power that prosecutors have in cases when they are charging people. One example I would give you is that prosecutors now routinely charge something called bail jumping. It was a charge when I was the prosecutor, wasn't used. They charge that so that they can get more leverage over the person who's accused so that they can get a plea bargain. I think that's something that is ripe for reform and something I would probably try to look at should some of those cases come into the Court of Appeals.
Candidate Latsinova.
The data, again, is striking. The United States has the rate of incarceration that is 7 times higher than in the rest of the industrialized world. This is shocking. And there are well-known roots for this problem. In the 70s, the war on drugs, and then the sentencing reform and such. And I agree that the Court of Appeals, unfortunately, has plays a limited role in changing these outcomes because the standard of review for sentencing decisions is abuse of discretion. That means that the Court of Appeals defers greatly to the trial court that imposed the sentencing decision. So I see primarily the role for the Court of Appeals as educational to make the public aware of what's going on. In addition, there's a statute, in fact, that requires the Court of Appeals to present to the Supreme Court, not to the public in general, but to the Supreme Court, gaps in the law. And this may be one of them, or at least it's something that can be raised.
Candidate Leishman.
The big policy choices that were made a while ago that resulted in this crisis are definitely beyond the scope of what any of us in the room can do in a minute, or any of us as judges would be able to do. But I wanted to call out one thing that I think is important here. Is Division I is a very efficient and large court, and they're very proud of that, and they do a good job. But a big chunk of that efficiency is routinizing criminal law and criminal appeals a lot of the time. And I think that this is a place where with some turnover in the court, with some distance perhaps, we might discover that some of the sentencing and some of the implicit bias outcomes are a result of just trying to get all those criminal cases through the system. And I think that a few more judges on this court who are a little less concerned about efficiency and a little more concerned about making sure that the system is working for everyone will have some positive outcomes for us as a society. Pardon me.
Candidate Keeler.
I think it's important for all branches of our government to be paying attention to studies like this that come out, to be looking at ourselves and saying, what are we doing, and is it being disproportionately applied to groups of individuals? Again, the policy decisions get to come from the legislative and executive branch, but the Court of Appeals is in a position of having hindsight, which is often said to be 20/20, over what's happened at the trial court level. So again, the Court of Appeals is there to apply the law, to make sure that it has been applied fairly. And I think by paying very close attention to those individual cases, on the occasion that something is not being applied fairly, or you're starting to see patterns of behavior, it's worth talking about, it's worth exploring, and if it doesn't apply in an individual decision because of the law, that maybe we talk about other opportunities to bring that to the attention of our society.
So sadly, we're at our last question, and that is, as we know, and some of you have touched on this in your answers here this afternoon, unlike criminal matters where the defendant has the right to an attorney, some people in civil cases cannot afford a lawyer, and the court is not required to appoint one. How can an appellate court judge ensure that people without lawyers are provided the same access to justice as people who are represented by a lawyer? And for this last question, let's start with candidate Latsinova.
I alluded to the answer to this question before. I think the Court of Appeals is not doing as good a job as other courts that I have seen have done in providing self-help manuals or guides for people who are unrepresented or underrepresented. I have seen much better materials in the courts in the state of Alaska, and there are much better materials provided in federal courts, in particular in the Ninth Circuit. There's a wonderful manual for people who are unrepresented to handle their own civil rights cases. I think these are the models that the Court of Appeals can follow in order to give people the tools they need to present their own case. That's where I would focus my attention.
And candidate Hernandez.
Thank you. I agree very strongly that this is one of the significant gaps in our system. I'm grateful to work as appointed counsel for people who would otherwise be appearing on their own. And I recognize the gaps that can occur when one side is represented by an attorney and the other is not. I agree wholeheartedly that one of the things that the Court of Appeals can do is to develop those materials so that if people are forced to appear on their own behalf, that they are given every opportunity and every tool available to be able to try to bridge that gap to the extent possible. I am keenly aware of the impact that literacy can have on a person's ability to represent themselves, language barriers in particular, because you may be literate in your primary language, but perhaps not in your secondary language. And so the subtle aspects of these pro se materials would be a critical focus as well.
Candidate Keeler.
I think first of all, you don't prejudge anyone, any case, that you treat everyone with dignity and respect, and you communicate clearly and understandably so that pro se individuals can do self-help. And I also think that the court needs to advocate for access to justice, to support funding for programs that allow increased self-help support, but frankly, there is no substitute sometimes for an advocate. And so that means that the court needs to advocate for programming to get people pro bono attorneys all the way up, from their trial work, their hearing work, their Court of Appeals work, their Supreme Court work. The courts can do that, and the Court of Appeals is not involved in that. And my whole career, I've been involved in ensuring civil legal aid and access to justice for everyone.
Candidate Seguine.
The law recognizes in some ways that some people represent themselves. There's a whole body of law out there in various forms about what we call them pro se litigants. And that law, it can be hard to apply, particularly for a judge. I've had many, many cases with pro se people in civil and criminal court, and I think that the bottom line here for a judge, any type of judge, is that you have to try to ensure fairness. And fairness is a very broad concept, but in the context of a person who's acting pro se, you have to try to dig through what that person's presenting, because they might not know exactly what they're presenting or if they're presenting it the right way. But there are cases I have seen where pro se people have very compelling cases, and they should be heard and not thrown out the door because the judge doesn't like the fact that there's no lawyer standing next to the person.
And Candidate Leishman.
I've spent a lot of my practice experience doing family law and civil rights law with people who are the most vulnerable, in the most need of help, and the most downtrodden by the system itself. I'm going to toss out a phrase that is a little loaded, but I think it's the right one here. It's the phrase is affirmative action. Judges need to do more. Judge Posner, who was the most distinguished judge in America, a federal court judge in Chicago, this year resigned from the court because he was fed up with what his colleagues were doing to the pro se litigants. They were just so impatient at the hassle of having people without lawyers that they were treating them unfairly. I think that that's something that drifts into law so easily. It's an adversary system. The judges can't do the work for you, but the judges can do more, and I think Division I is an example. The Court of Appeals is an example where I was reading a case where it didn't make sense. So I went back and looked at the briefs underlying it, and I realized because it was the pro se, the court made the wrong decision. We can do more, and we should do more.
I'm going to slip in one more quick question. It's so quick, it'll work. What Supreme Court justice, living or deceased, do you most admire? Candidate Seguine. Good one.
United States Supreme Court, I guess we have to qualify that.
Why don't you just answer it as it feels right to you?
I'm going to say for the moment, and Justice Roberts, and maybe that doesn't please everyone, but it seems to me that Justice Roberts came in on a wave of, Chief Justice Roberts, on a wave of partisanship that a lot of people criticized him for. And in the Obamacare decision, I think that he elevated himself to some degree, and I'm sure some folks will disagree with me, but he supported that legislation in the end, much to the consternation of the group of people who were responsible for him getting there. And I think that's an attribute that everybody needs to think about in terms of being a judge, is that, it was alluded to earlier, is that there has to be some willingness to look the other way against what your beliefs are that maybe you were built upon, and look at what is not politically correct or popular at the moment, but what you believe to be right legally.
Candidate Leishman.
I would say Justice Blackmun, Harry Blackmun, who, when I was in law school in the 80s and 90s, I graduated in 1990, but Justice Blackmun came and spoke. One of my friends was clerking for him. He came to Yale, and this was at a time when Roe v. Wade was under as intense attack as it is now, and so much was going on. And Justice Blackmun was so serene. I mean, partly he had the beautiful white hair and looked like a justice, but people asked him, and he just was so confident that the system will work, that in the long run, if we keep trying, if we try to get it right, if we try to be fair, that little things might happen along the way, and there'll be people who are disappointed. But I was just so impressed at his serene confidence that the rule of law is something that is tough and that is going to be around, and we can do what we can to make it work.
Candidate Latsinova.
I have to mention 3 names. I can't limit it to one. On the U.S. Supreme Court, I would say my favorite justice is David Souter, because he is independent. He was independent when he served on the Supreme Court. Regardless of who appointed him, you always knew that you got his best judgment and his best thinking in every decision. On the state Supreme Court, I would say is Justice Robert Utter, and I admire him especially for his scholarship on the differences between Washington state constitution and the federal constitution. He was a pioneer in that regard, and he wrote about it, and we all benefit from it. And one more person that I must mention is the Court of Appeals late Judge Susan Agate, who was a shining star on the Court of Appeals and also a wonderful person. I'm privileged to have known her.
Candidate Keeler.
So I would pick my Supreme Court justice just from a personal standpoint, and that would be Justice Sandra Day O'Connor. It means a lot as a young woman to see a woman serving on the U.S. Supreme Court bench and to trailblaze her, for her and now the current 3 sitting there. I am going to mention the Washington State Supreme Court, which currently has a supermajority of women serving, one of whom is Justice Deborah Stevens, who I admire greatly. The first time I saw her argue as an appellate attorney, it was obvious that she was prepared, she was brilliant, and she was articulate. And I think what I appreciate of her now is that she communicates clearly and writes cases where I can see that analysis. And so those are the 2 I'll name today.
And Candidate Hernandez.
Thank you. I think the justice who has had the biggest impact on me professionally, certainly from a distance, would be Justice Sotomayor. Watching her nomination and confirmation process, watching the decisions that she's made, and learning from her process, again from afar, certainly, has been incredibly inspiring. There's a quote of hers that talks about how the life experiences that we carry shape the facts which judges choose to see. And certainly all of us carry wonderfully diverse life experiences on this panel, and we would strive for impartiality and fairness in our work. But the reality is that those life experiences do matter. They do shape the lens through which we view the law.
So, sadly, from my point of view, we're at our closing statements, because I would like to hear from all of you at even greater length, but it's time for us to draw this to a close, and we'll start with Candidate Leishman, please.
I started thinking about being a judge about 10 years ago when I was on the Judicial Evaluation Committee for the Bar Association, and it wasn't that I thought these people would come in and I thought, oh, I could do that. It was more this kind of afternoon where we talk about what does it mean to be a judge? What is justice? How can we do better? That has been something that just has fascinated me ever since I went to law school. I've just always been driven by this thirst for justice, for public service, and this recognition that this is a particularly interesting and useful way to do it. And so I've been asking myself these kinds of questions for 10 years, and I just really appreciate the opportunity to sit here again, because it just makes me more and more excited about the future, about the kind of a judge I would want to be and I would strive to be, the kind of community I want to be a part of. And I ask you to go to my webpage, learn a little more about me from where I've come from. But thank you so much for caring enough to come and listen and participate in this dialogue today. Thank you.
Candidate Keeler.
So thank you again for having me. I'm going to repeat a little bit of what I said at the beginning, which is I love the law. And I care about my community, I care about the impact the law has on people, and I want to be of service. And I think those things have come to me in my life because my mother taught me to be a philosopher and an anthropologist, and also to use your skills, whatever they are, to serve those around you. I am the youngest candidate sitting up here, and yet in my time practicing, I have done civil work and some criminal work and some family law work, and I am the only candidate with any judicial experience. And I am the candidate with the most broad judicial endorsements. And the reason is from the very beginning, I built a reputation of professional integrity, of community service, and high legal acumen. And that's why I'm asking everyone to vote for me, Lisa Keeler. Thank you.
Candidate Seguine.
We have a great set of candidates up here. This isn't just a technical job. This is a job that is set up to provide service and representation to the voters of the 4 counties. I have lived and worked here with my wife since 1990. My wife has worked for the city of Mount Vernon and Skagit County. She wants to retire now, which is another issue. But we've lived here, we've worked here, we played here, and quite frankly, I've kind of gotten old here. And over that time period, I've had the pleasure of meeting a lot of people, friends, colleagues, extended family, and this is the only position on the Court of Appeals. It's been mentioned there's 10 judges, the only position for these 4 counties. And I am asking you to just think about voting for me, in part because I have been here for that long, and I feel like I have, respectfully, more than the other candidates, a better ability to represent you, all things considered. So I'd ask for your vote on August 7th. Thank you so much.
And Candidate Hernandez.
Thank you. As candidate Seguine indicates, this is a regional seat, and that is very important. That is by design. The statute, the constitutional amendment that set up the Court of Appeals did want to have that representation regionally. I have deep ties to this community, deep experience in working with people who have traditionally been left out of the conversations that are important to our communities. I was asked and encouraged to run by members of the local legal community because of the reputation that I have developed as a person of integrity, a person whose word matters, and a person who truly seeks justice in her work. It matters to me to maintain a diversity of experience on our bench in addition to regional diversity, and having a defense perspective, an immigration perspective, and work previously in civil matters like family law and landlord-tenant helps me provide that to Division 1. Thank you.
And Candidate Latsinova.
I guess I'm last, and now that everybody has revealed their age, I can say I'm the oldest one in this group. Because I turned 58 in June. I would like to say thank you for spending part of your afternoon listening to us talk about why we want to be the next Court of Appeals judge. And I just want to mention that I'm really, really proud of one endorsement, and it is by Justice Phil Talmadge, who served with great distinction on State Supreme Court. And I'm especially proud of his endorsement because he knows my work. He knows my work when I argued before the Supreme Court. He knows my work when I argued before the Court of Appeals. And he knows my work because he's now in private practice as an appellate lawyer, and we argued side by side in one case and divided our argument in half. I had 10 minutes and he had 10 minutes. And so his endorsement means a lot to me. So if I am elected, I would like to be worthy of his endorsement and do live up to the endorsement that he gave me. Thank you.
I'd ask you to please join me in thanking all of the candidates for being here today and for running for public office. Thank you.